Hi, welcome back. In this module, we're talking about obligations that exist regardless of a contract. These are obligations and rights that we have without having the need to contract for them. And of course, when we are talking about rights and obligations, we have to discuss the Constitution. The Constitution is the country's foundational document, meaning everything flows from the Constitution. It is the supreme law of the land. And when I wrote that phrase, supreme law of the land, it didn't dawn on me for a couple of minutes as to what I'm talking about. And the fact is, that's what it says in the Constitution. There's no higher authority than the United States Constitution. And one of the key things that the Constitution does is it reduces barriers to commercial activity. So business is really at the heart of what the Constitution is about. So today we're going to look at the Constitution and discuss the ways that it affects business. Now, the Constitution in the United States has a unique structure. That structure is based on a concept called federalism. Federalism involves the dividing of power, and in this case, the United States has a government that consists of two distinct levels of government, which is to say federal and state. The Constitution grants certain exclusive powers to the federal government, but then there are also powers shared by the federal government and the states. And then there are some powers that are reserved to the states that the government cannot regulate. So federalism produces a dual sovereign system wherein in some situations the United States, the federal government is the sovereign. In other situations, the state is the sovereign. Now, another unique concept of the Constitution involves a notion called separation of powers. And separation of powers was vital to the idea of the Constitution as envisioned by the founders. They did not want a system in which one branch of government held all of the authority. This is what England had, essentially, wherein it was the legislature, it was the parliament who controlled much of the power within the English government. And the founding fathers wanted to avoid that. And so what they did is they split the power up. They created multiple power centers within the same level of government. So all of these are at the same level. The federal government has these three equal components. First of all, the legislative branch, which consists of Congress. The executive branch, which is the president, the office of the presidency. And finally, the judicial branch, which consists of a federal court system. And as we've discussed, the federal court system, a very complex and convoluted situation. The reason why we have these dual court systems that we discussed earlier is because of this notion of federalism. Let's begin by looking at some of the federal powers that are expressly granted to the federal government. Now, one of the things that makes the Constitution unique is the idea that it is a government of limited powers. The federal government has no inherent authority. What in the law we call that plenary power. Plenary power is the power that you have simply by being a state. But the federal government does not have plenary power. Instead, the federal government has limited powers. The only thing that the federal government can do are those things in which it was granted the power to do by the states. When the federal government was created, each of the states gave up a little bit of its sovereignty to the federal government while retaining sovereignty for other areas. And so when we talk about federal powers, all of these federal powers are necessarily limited because the Constitution has created a limited form of government. Let's start with the Congress. Article 1. So, Article 1 of the Constitution created the Congress, and it established a bicameral legislature, two houses, the House of Representatives and the Senate, who have the power to make laws. The House of Representatives, supposedly the representative aspect of society. The Senate was meant to be an older, expressly older, more contemplative body, a group of wise, older legislators who would oversee the rambunctiousness of the House of Representatives, to keep a lid on what exactly came out of the House. Now, Article 1 delegates a finite and specific set of enumerated powers to Congress. We're not going to discuss them too much here, but you can read more about them in your book. The office of the presidency is created in Article 2. And Article 2 of the Constitution vests what's called executive power in the president. And again, under executive powers, these powers include, first of all, the position of commander-in-chief of the armed forces. The president has the power to enforce the laws that are made by Congress. The president has the power to conduct foreign relations and negotiate treaties with other countries. And finally, the president has the power to appoint federal judges subject to Senate approval, confirmation by the Senate. And again, the Senate was meant to be this older, wiser group that would serve to assist and advise the president. And so that's why we have this idea of Senate confirmation for federal judges. Now, the third power has to do with the federal courts, the federal court system. Article 3 of the Constitution vests judicial power in one Supreme Court, and it also permits inferior federal courts to be established by Congress. So the entire federal court system is based on Article 3 and this grant of power to Congress to create additional federal courts. The Constitution only created the Supreme Court, but it gave to Congress the authority to create additional federal courts. Now, judges, as we mentioned, have the power to interpret laws, and when they interpret those laws, they tend to shape those laws in a distinctive direction. And finally, the doctrine of judicial review. This is a doctrine that says courts have the power, the authority to invalidate state or federal laws that conflict with the Constitution. And we've mentioned this before, that the idea that the court system has the power to review each law and decide whether it comports with the Constitution. Did Congress have the authority to pass this law? And this is why we have these debates about constitutionality and courts declaring a law unconstitutional. And what's usually is happening when they do that is they're saying that Congress did not have the power to establish this law, or the president didn't have the power to create this rule or regulation. Now, the origin of the Constitution is founded in a desire to promote business. Business was at the heart of the Constitution. The drafters of the Constitution were not the same people who drafted the Declaration of Independence. The Declaration of Independence was a revolutionary document calling for overthrow of the government. This was a document authored by Thomas Jefferson and overseen by a number of other revolutionaries, people that wanted to do away with the existing government. Very different group created the Constitution. In fact, Thomas Jefferson was specifically disinvited from the Constitutional Convention. He was not allowed to attend the Constitutional Convention because the drafters of the Constitution were ready to start their lives again, to promote the businesses and to promote commercial activity. And so in many ways, the Constitution is designed to promote this commercial activity. Now, before the Constitution, remember the Constitution is not the first organizational document for the United States of America. That came with a document called the Articles of Confederation. The Articles of Confederation were also a federal form of government. However, with the Articles, the states retained most of their powers. And one of the most important powers that the states had was the ability to tax goods brought in from a neighboring state. And so this ability to tax your neighbors, and which is the primary means of raising money, this led to a battle within the states in which each state would raise taxes on their neighbor. The neighbor would raise taxes on the original state, and then they would go on and on and on. So that by a few years after the Revolution, it was less expensive for the textile merchants in New England to import cotton from England than it was from South Carolina. And so we have a situation where the foundational document created the ability to hamper commercial activity. And the drafters of the Constitution recognized that the country needed a governing document that promoted rather than hindered business. And so business was really at the heart of the Constitution. And in fact, it was a financial crisis that spurred the call for a constitutional convention. Again, under the Articles of Confederation, the power of the federal government was severely restricted, most prominently in this idea of imposing tariffs on other states. Now, there was a huge debt crisis that took place following the Revolution. Every state had spent a lot of money in fighting the American Revolution. We tend to think of the American Revolution as starting and ending fairly quickly, but instead it was a long, difficult war fought over a 7-year period, at which point all of the states were exhausted, physically, of course, but also financially. And so the states started raising these tariffs on other states in order to raise money to cover the debts that were accrued during the Revolutionary War. Now, the Constitution was adopted to create an economic climate that would enhance stability and security. The Constitution included certain key provisions to decrease the barriers to commercial activity, starting with the Full Faith and Credit Clause. The Full Faith and Credit Clause states that a state must honor the laws and judicial decisions of other states. The Full Faith and Credit Clause arose in large part because as debtors were sued in one state by residents of another state, that original state would create a means of immunizing their own citizens and stopping the resident of the other state from collecting on their debt. And again, it was a tit-for-tat situation in which other states retaliated by doing the same thing. And so what the Full Faith and Credit Clause says in the Constitution is that no one should be prejudiced in one state because they are residents of another state. And again, this was primarily to promote commercial activity so that lenders would not fear lending money to a resident of another state, secure in the knowledge that they could go into that other state's courts and exercise their rights against the debtor. Another important clause is the Privileges and Immunities Clause, which prevents any state from discriminating against citizens of other states in favor of its own residents. So that if you want to go work in Idaho following your graduation from OSU, you are able to do so. Idaho cannot pass a law restricting employment to Idaho residents. We actually saw this back in the 1970s. There was a desire to build a pipeline that ran all the way from Alaska to the continental United States. Alaska, of course, turned out to be a treasure trove of oil, and which was important because the Middle East states had recently embargoed oil and made it difficult to purchase oil. And so there was this need to build a pipeline, and the pipeline had to be built quickly. And there was a gold rush, in essence, of machinists and pipe workers and other trades who went to Alaska to work on the pipeline. Alaska, the state, was concerned that Alaska residents were missing out on this economic boom, and so they passed a law restricting employment to those outside of Alaska citizenship, meaning the employer had to first evaluate an Alaskan citizen for the job before they could hire anybody not from Alaska. Now, this case, there was a lawsuit filed. The case went all the way to the Supreme Court, and the Supreme Court agreed that this provision violated the Privileges and Immunities Clause. Now, the final power that we're going to talk about is the Commerce Clause. The Commerce Clause gives to the federal government the power to regulate national and international business activity. And in fact, Congress derives most of its powers from its ability to regulate interstate commerce. So Congress has the power to regulate commerce because of this clause, the Commerce Clause. The Commerce Clause gives to Congress the power to regulate interstate activity. And the Commerce Clause, again, was at the heart of the Constitution, which was to say to prevent states from making business activity more difficult between the states. The Supreme Court has interpreted Congress's Commerce Clause very broadly. Congress can use its commerce power strategically to regulate almost any aspect of business. And in fact, the Supreme Court has ruled that Congress even can regulate purely intrastate conduct if that intrastate conduct affects interstate commerce. So if intrastate conduct produces a substantial economic effect on interstate commerce, the Congress can regulate even that activity that is conducted solely within a state borders. So the Commerce Clause provided the federal government with expanded powers. And really we saw this at its maximum in a case called Wickard v. Filburn. This was back during World War II, and the Congress, in an attempt to remedy low wheat prices, had put a quota on how much wheat a farmer could sell. Well, in this case, Mr. Wickard, the plaintiff, was a farmer, and he decided to grow some wheat only for personal consumption, not to enter into the flow of commerce, but solely for personal consumption by him and his family. But in doing so, he violated the quota set by the federal government, who then sued him in court. This is a case that went all the way to the Supreme Court, and the Supreme Court concluded that growing this produce for his own personal consumption would affect interstate activity because he would not be buying that wheat from elsewhere. And so this was at this point, there was very little that the government could not regulate through the Interstate Commerce Clause. And in fact, the Commerce Clause authorized the civil rights legislation of the 1960s. When you think about what was underlying things like the Civil Rights Act of 1964, the authority for that, you may think it's in the Bill of Rights or maybe in the 14th Amendment Equal Protection Clause. Well, none of that is true. It's authorized by the Commerce Clause. And we saw this in a case called In Heart of Atlanta Motel versus United States. This was a hotel in Georgia that was provided only for whites, that you could not stay there if you were a person of color. In this case, however, the court found that by preventing blacks people from registering at the hotel, then they were affecting other commercial activity, including interstate commerce. So it is a broad power. The Interstate Commerce Clause also is what gives to Congress the power to regulate illegal drugs, for instance. Commerce Clause power. Make sure you think about that for your test, because there will doubtless be a question on that topic. Now, there's also what's called a negative Commerce Clause effect, oftentimes referred to as the dormant side of it. And the negative Commerce Clause, the dormant Commerce Clause, says that the Commerce Clause has this ability, this grants this ability to regulate interstate commerce to the federal government. Well, the dormant side says that if a state attempts to regulate an activity, and in doing so it affects interstate commerce, that state's law has violated the Interstate Commerce Clause. Even though Congress has not regulated this particular activity, if the state attempts to regulate it, then that gives to the federal government the power. So states cannot discriminate against or unduly burden interstate commerce. The broad nature of the Commerce Clause has caused some concern in society. And we have seen examples of the Supreme Court attempting to impose limits on the commerce power. Because up until the 1990s, probably, the Commerce Clause was so broad that it effectively allowed Congress to regulate anything. And so in the 1990s, we saw some first attempts to restrict the power of Congress in its Interstate Commerce Clause. For instance, there was a case involving the violence against women, domestic violence. It gave to women who had suffered domestic violence the ability to file a claim in the federal court system. And the authority was the Commerce Clause, that domestic violence, violence against women, it was called the Violence Against Women Act, that domestic violence affected interstate activity and therefore Congress had the power to regulate it. The Supreme Court disagreed and said there are limits to the powers of the Commerce Clause. Another case involving a Guns in School Zones Act, meaning there was a federal law banning the carrying of weapons within a certain radius of a school. And again, authorized under the Commerce Clause, but the Supreme Court disagreed. Probably the most recent attempt by the Supreme Court to limit the power of Congress has to do with the Affordable Care Act, what we call Obamacare. Obamacare passed in 2010, enacted by the legislature. One of the key aspects of the Affordable Care Act was what was called the individual mandate. which said that everyone had to buy medical insurance, that the system envisioned by the Affordable Care Act could not exist unless everyone bought insurance. People who don't buy insurance become free riders on the system. And so there was this mandate put in place that everyone had to buy health care. Now, the government was going to provide low-cost health care insurance or access to low-cost health insurance. But nevertheless, everyone had to participate in this. Now, a number of states, as well as the National Federation of Independent Business, sued the federal government, claiming that the individual mandate was not authorized by the Commerce Clause. Congress did not have the power to regulate the purchase of employment. And the Supreme Court agreed, saying that Congress, although they had the ability to regulate interstate commerce, they could not then force individuals to enter into the stream of interstate commerce. And so we have a situation where this power of Congress was overridden by the Supreme Court. Now, Obamacare continued in large part because the mandate carried a penalty associated with failing to buy insurance, and the Supreme Court, decided that this penalty was a tax, and Congress has the power to tax and spend. That's one of its most important powers, and therefore the statute continued on and remains in effect today. Now, the Bill of Rights is the final aspect of the Constitution we're going to look at. It limits the power of government. You've probably heard about the Bill of Rights. It refers to the first 10 amendments to the Constitution. And what the Bill of Rights was intended to do was to appease opponents to the Constitution who were fearful of a federal government with too much power. Again, put yourself in the mindset of the late 18th century residents of the United States who had seen a federal government, the English government, abuse its powers. And so many opposed the idea of creating a powerful federal government. Now, the drafters of the Constitution did not oppose these limits on the federal government. One often hears about the controversy in creating the Bill of Rights, but that controversy was actually very limited. The drafters of the Constitution were interested in business and promoting commercial activity, and, oh yeah, by the way, also guaranteeing certain rights. And those came in the Bill of Rights, the first 10 changes to the Constitution. And what the Bill of Rights does is it limits federal powers by enumerating state and individual guarantees and rights. Now, the Bill of Rights is only directed at Congress, but in the 14th Amendment, most of the Bill of Rights was made applicable to the states, meaning now the states are under the same limitations as Congress is in the Bill of Rights. Now, you've heard of a number of these amendments. We're going to talk about probably the most important for business purposes. First of all, having to do with the First Amendment. The First Amendment protects individual liberties in 3 different areas: religion, speech, and association. So, a broad guarantee of protection in the First Amendment. And again, these are areas, speech, assembly, and religion, all of which were central to the idea of the United States and were an attempt to distinguish it from England and its former colonial power. Now, most of the protections in the Bill of Rights apply only against the government, not against private business firms. So therefore, you as a worker don't have a First Amendment right to speak on the job. It simply means you can't be prosecuted by the government for speaking. The Supreme Court has also provided lesser protection for commercial speech than for political speech. Right now, there's a huge debate about social media and how much protection is the social media company itself entitled to, how much protection are the people commenting on social media protected to. And so that's a real issue. The next amendment applicable to business is the Fourth Amendment, which is Search and Seizure Amendment. And what the Fourth Amendment does is it prohibits unreasonable searches and seizures. Now, how do we know what is an unreasonable search and seizure? Well, a reasonable search and seizure involves the issuance of a warrant by a neutral third party, by some magistrate or judge. That warrant must be supported by probable cause, meaning there must be something that exists that gives to the government the right to search and seize property. Furthermore, that probable cause has to be supported by an oath, meaning someone has to swear to the truth of it. And so getting a warrant, a search warrant, I'm sure you've heard the term on TV, should be a difficult thing to do, in large part because it has to be supported by these elements, that there must be probable cause and someone must be willing to swear to that probable cause. In fact, the Fourth Amendment is so important that we have created a rule called the exclusionary rule that says that any evidence obtained in violation of the Fourth Amendment is not admissible at a criminal trial. So the exclusionary rule is a means of enforcing the unreasonable search and seizure prohibition found in the Constitution. The Fifth Amendment does a number of things. The Fifth Amendment is a very broad amendment. One of the most important things it does, and the one that you most hear about when hearing about the Fifth Amendment, is it protects individuals from being compelled to be witnesses against themselves in a criminal case. You will often see people on TV taking the Fifth Amendment. The Fifth Amendment guarantees a person the right to not speak against themselves, from being forced to be a witness against themselves. The Fifth Amendment also contains a version of the Due Process Clause, which says that there must be due process of law before a citizen can be deprived of life, liberty, or property. There's also the Takings Clause found in the Fifth Amendment. It says that the government may have the ability to take private property for public use, but only if just compensation is paid to the property owner, meaning the value of the property that is seized must be paid to the property owner. Just compensation usually means the fair market value at the time of taking. The Ninth Amendment states that there are unenumerated rights, rights that are not specifically set out in the Constitution, but may exist in the hands of the people. So the federal government can't infringe on any rights, even though those rights are not enumerated in the Constitution. So regardless of whether the rights are specifically listed in the Constitution, you still have those protections against government interference with those rights. And so we don't know how many rights that you have, but they are more than what is found in the Constitution. Individuals can have additional rights, even if they are not mentioned in the Constitution. Finally, the 10th Amendment, this is a federalism restatement that the United States is organized with two separate sources of political power, the states and the federal government. Many today would argue that the federal government has become too powerful and the states have become too limited. The 10th Amendment was designed to reinforce the idea that there were these two sources of power. Remember, the drafters of the Constitution were afraid of a powerful federal government, and they believed that states would be the ultimate protector of their liberties. And so therefore, the states we wanted to ensure the power of the states continues. And so in the 10th Amendment, it says that any power not delegated to the federal government in the Constitution is retained by the states. Powers that are not delegated to the government are retained by the people. Finally, let's expand a little bit on these phrases that come out of the 5th and 14th Amendments, and that's due process and equal protection. You've probably heard the phrase due process of law. Both the 5th and the 14th Amendments of the Constitution state that no person shall be deprived of life, liberty, or property without due process of law. Due process means that the procedures followed by the government must be fair. Due process essentially means the government must have a rule and it must follow the rule. Have a rule and follow the rule. Now, with due process, we're really talking about two aspects: that a party charged with a crime should have notice of the charge, meaning specific detailed information as to how this person has violated the law, and they must also be given an opportunity to be heard by a neutral third party. And so that's what due process refers to. Now, we break this due process down into two aspects. One is procedural due process, and that's what we're talking about, is that there must be procedures in place. The procedures don't have to guarantee that you have a chance at trial. It doesn't mean that everything is 50-50 when you go to trial. It simply says the government must have rules and they must follow those rules. And so if you ever hear about an indictment, what is an indictment? An indictment is official notification of the rule that has been violated. And it also gives the opportunity to the defendant to be heard. There must be some opportunity for hearing. If you are ever stopped for a traffic ticket and you are given the ticket is the notification that you have committed a wrong. And you'll notice on every ticket that you've ever gotten, if you've ever gotten one, is there will be a date set, a person to whom you are going to present yourself to answer whether you are liable for the speeding ticket or not. There is another aspect of due process, substantive due process, and what substantive due process does, it really limits the ability of government to interfere with individual responsibilities, activities. In essence, what substantive due process means is that the government must have a good reason for the things that it does. That if the government is going to restrict the powers of people, it must have a really good reason for doing so. Finally, equal protection. The 14th Amendment provides that equal protection requires the government to treat people who are similarly situated equally. The 14th Amendment really changed the nature of the Constitution through this idea of equal protection, because for the first time in American history, everyone was equal before the law. And this comes out of the Equal Protection Clause, that if two children are born in the same hospital on the same day, they should have an equal opportunity in life. The government may also create different categories, but each individual in the category must be treated the same. So in conclusion, what did we learn in this lecture? The Constitution has a unique structure. Congress derives most of its power from its ability to regulate interstate commerce, and the Bill of Rights limits the powers of the federal government and state governments through the incorporation aspect of the 14th Amendment. That's all for this one. If you have any questions, please let me know. Otherwise, we will see you soon. Thanks for listening.